On the Employment Equity Bill will soon kick off in Parliament's Portfolio Committee on Labour. 3 days of public hearings into the matter saw numerous submissions from various interested entities. The Employment Equity Act is one of the cornerstones of South Africa's labour legislation. It's the first time amendments are made to the Act since its implementation in 1998. The amendments were also deliberated on extensively at NEDLAC. Abra Babia followed the proceedings and compiled this report.
Many presenters did not want the Act to be tampered with too much. One section has them particularly concerned. The amendment, if approved, would mean that business, if slapped with a compliance order by the Labour Department, simply have to comply without any sort of negotiation in between. As things stand, there are processes business could follow with the department to negotiate.
I've got friends who are labour lawyers and they're rubbing their hands and waiting for this because they're going to make a lot of money out of this. They could overload the labour court and get in the way of more important cases.
It is trite to say that our system of labour relations is based in consultation and negotiation. Unlike our past, the labour community don't have to resort to court action immediately. Now South Africa's become famous in the world for this, that we go out and we negotiate, we consult, we talk before we get to court action. And what these amendments are trying to do are trying to force us into the courts, which I think is silly in its essence. The suggested amendments will change the very nature of the system and force the parties to resort to a fight as opposed to a discussion.
But the committee has heeded these concerns.
We take seriously the concern that if the process is taken directly to courts, that it will make the legal processes more expensive for all the parties and therefore delay litigation. And we are going to be taking that into strong consideration.
Trade Union Solidarity also made an oral submission. It says the introduction of the Employment Equity Amendment Bill will negate government's goal of producing more decent jobs and sustainable livelihoods. It's concerned about the impact of the new proposed labour legislation. Solidarity says the effect will place a further administrative burden on employers and employees. It says number crunching in terms of representation often results in on-the-job effectiveness being sacrificed. The union's main concern with the proposals are in changes to Section 42. It relates to affirmative action being implemented through looking at a pool of suitably qualified people from designation groups. That clause may now be scrapped.
Further important point of this racial demographic representativity ideology is that it does not take into account the factors enumerated in Section 42 of the EEA and is based on pure racial profiling.
Yes, there may be concerns on Section 42 on your part, but I think in the broader sense, essentially what has happened in the last 19 years is not indicative of the transformation which we want to see.
Solidarity says it does acknowledge the importance of redress.
We are dealing with difficult issues. We cannot look away from that. And as Solidarity, we are also concerned about the issues, the social issues in this country. And your question, we do plea for social dialogue. Yes, that is correct. And the reason, therefore, is we would like to be part of the solution, and we believe that we can contribute to a certain extent to the solutions.
The Centre for Constitutional Rights raised concerns about the proposed amendments not being in keeping with the Constitution, while Trade Union Federation COSATU, however, says it largely supports the bill. Its comments during the last day of the hearings mostly dealt with technical objectives. But it stressed that it remains concerned about the lack of impact of employment equity legislation on the lives of black women in South Africa. COSATU is especially satisfied with a provision prohibiting unfair discrimination for work of equal value. It referred to an international labour organization critique on this matter. South Africa is a member state of the ILO. And one of the objects of the bill is to give effect to South Africa's obligations as a member state.
The ILO has criticized South Africa, and we think it is correct for not having passed legislation to address the redress of discrimination where it relates to work of equal value. And historically, we understand that this tended to be associated with discrimination on the lines of gender, but in South Africa, it is gender as well as race.
In the amendment bill, the Labour Minister is authorised to prescribe criteria for assessing work of equal value. The committee says submissions over the past 3 days has given it lots to consider.
We will at all times obviously take into consideration the fact that there are historical injustices which needs to be addressed, which has been the essence of the Employment Equity Act and which we think is the essence of the current Employment Equity Amendments Bill. Those, and I think there are a lot of presentations which have been made to the effect that yes, there is a problem with the extent of the punitive measures which are in place, and that we need to change those, and that government needs to be seen to be taking serious action against those who do not comply with the law. But consistently, as part of not only this legislation process, but also as part of our oversight, we will also be looking at the role of the department in ensuring that there is compliance. This committee has consistently, I think for the last 2 to 3 years, in the budget votes, argued for more resources for the Department of Labour, because we agree with the trade unions, we agree with business, we agree with civil society, we agree with the many people who made presentations here that there is a need to ensure that there is compliance.
Manamela says the committee will also seriously consider the NEDLAC deliberations. Some of the objectives of the bill seeks to enhance the effectiveness of the CCMA and the Labour Inspectorate. But most importantly, it wants to rectify issues that have arisen from the interpretation and application of the Act in the first decade. Abra Barbia for A View from the House.
Let's take a break. A View from the House will continue in a moment. Don't go away.